Mr. Geiger, Mr. Baker gave us a couple of examples about the positive use of 2015. I could give you a dozen more. Do you know of any abuse of the use of 215?
If there was an abuse of Section 215, it is unlikely that the public is going to know about it because that abuse would be classified. It would be shrouded in secrecy. But certainly, the overbroad use of Section 215 has resulted in a loss of trust in American companies and is translated to real dollar loss and lost jobs. Moreover, mass surveillance itself is an abuse. It's an abuse of privacy rights of Americans and human rights of people abroad. And the government has a history of abuse, not just this government, but governments worldwide, when surveillance power is too broad. Lastly, there's not a lot of evidence that the authorities are in fact effective. We've had multiple independent review boards, including the Privacy and Civil Liberties Oversight Board and the President's Review Group, as well as members of this panel, who have reviewed the classified evidence and have determined that less intrusive means could achieve the same ends. So I would say, not only do I not have information about abuse, I in fact have information that the authorities that you're asking about are not effective.
Well, I would strongly disagree with you. And just as a simple example that Mr. Baker gave about the Zazi case, had we not had 215, I'm convinced that if we had this bill in place under the facts of the Zazi case, we'd have probably had an explosion in the subway in New York City. And the reaction that we had after 9/11 that you referred to that may be overstepped, and I understand exactly what you're saying. That's the way Congress tends to act, unfortunately. The reaction would have been to the point, in my opinion, where we wouldn't be here today talking about modifying them in a softer way. We'd be talking about modifying them in a stronger way. Mr. Baker, you were at Homeland Security till 2009 or so.
Yes, sir.
I'm not sure how much access you had to reviewing cases that may have involved the use of 215. But can you shed any light on this from the standpoint of any, number one, abuses or reasons why, even stronger reasons why 215 should be maintained?
Well, actually, I heard Mr. Geiger say he didn't know of any abuses, and I agree with that. I did not see abuses, and I will say we felt so strongly about the importance of having a large data set that we had bitter battles with the European Union to make sure that we could get information on everyone who was flying into the United States. And of course, most of them were innocent, but we needed the data so that we could go through it and look for the most suspect passengers and give them a little bit more questioning at the border. It was an enormously effective program that relied on having a comprehensive database, not a selective database based on 5 magic terms.
Mm-hmm. Mr. Senator, if I can clarify my earlier statement, what I had said was that the overbroad use of 215 is problematic. I can see 215 being used in a variety of different circumstances that are not bulk collection, and certainly they can be useful in that context. Rather, the evidence that has been compiled so far is that the bulk collection programs themselves are problematic, and it is that we are trying to end.
Yeah, I understand that. Mr. Woods, if and I'm going to ask you this. You may not be able to answer it because it would relate to practices of your competitors, but I assume there are some generalities in your industry. Let's say you were mandated to keep records by this law that we're debating and ultimately may pass. If you were mandated to keep records for up to 18 months. Do you have any idea what that would cost your industry?
No, Senator, I don't have any reliable figures.
Would there be a cost to it?
Certainly increased storage space would be a cost. I have no idea of the magnitude.
Okay. let's say we don't mandate it and leave it wide open as the House did, which I think is a huge mistake. And let's say that you received a query on one of your customers who was in conversation with a customer of AT&T, who was then in contact with a customer of Sprint. Under this bill, as I understand it, if you got a query, then you would give information on your customer, then we'd have to go back, DOJ would have to go back to the FISA court to get a authorization for a query on the AT&T customer, and then they'd have to go back to the FISA court and get a query on the Sprint customer. Is that your understanding?
I'm not sure exactly how the process would work. We would respond with the call detail records of whatever we had. We would certainly have the call detail records on our customer. We also have call detail records on telephone calls that are not by our customers but transit our system, as we handle a lot of what we would used to call long distance and a lot of international calling. So we would simply respond with as much as we had, which might be the call from the Verizon customer to the AT&T customer. It might conceivably include other CDRs relevant.
It might, but it might not.
It might not, and that is totally dependent on how the call is routed through the telephone infrastructure.
Yeah, which makes my point that, as Mr. Baker said, and well, and as you said too, right now we've got it all collected at one point, and there's only one query, and that one query gives us all of the numbers in that little spider web that is built when a terrorist makes a phone call to somebody who makes another call. And the information is available instantaneously, as opposed to maybe being received by NSA or FBI or whoever may request it over a period of hours, maybe even days, I guess, conceivably. So the chairman's right. This is, and I understand your both the problem that you, Mr. Garfield, and you, Mr. Geiger, have raised relative to the economic issues and whatnot. But let's don't kid ourselves. We're not the only ones that do this. I mean, we've got folks across the pond who do this against us. So, and it's been necessary to interrupt and disrupt terrorist activities. And you wanted to say something, Mr. Garfield.
I just want to be clear that we're not suggesting not engaging in activity that would protect our national interests, national security interests. The thing that we're suggesting is, particularly as it relates to the language in the bill, that there are ways to do that while also addressing the equities related to privacy. And so behind you is a seal of the United States where it says e pluribus unum. If it turns out that the American people have completely lost trust in its own government, both domestically and internationally, then the impacts of these programs, it's not going to be specious, it's going to be quite significant. And so I think it's important to come up with language that achieves what you want, but also that ensures that we're not doing it in an indiscriminate way.
And I don't think there's anybody here that disagrees with that philosophy. I do think that there's going to be some disagreement over how we get there, but.
I think she said it.
Okay. Well,
Senator, if I can respond to your points about data retention. So, as has been noted earlier, the telecommunications companies, as well as many other internet services, already receive millions of requests from law enforcement around the country every year. And they are responding to that. And law enforcement generally does not have the ability to build such a gigantic database. There has not been any evidence so far that we have seen that a data retention mandate is necessary for the companies to fulfill these requests or for law enforcement to use the data from these requests to actually catch criminals. Moreover, a data retention mandate would be an enormous burden both in terms of technological infrastructure, particularly for small companies and startups, but it would also result in loss of user trust and potential problems with privacy and data breach. So we urge you not to go down the road of a data retention mandate.
Well, the problem is, though, as Mr. Woods said, they may not keep these records more than 2 months next year. And things are going to change 5 years from now or 3 years from now. We all know how fast technology changes. And if there's not some requirement they be kept for some period of time, then we may as well not have this program. We will lose it, and we will lose the ability to interrupt and disrupt terrorist activity. So there's going to have to be some kind of understanding or mandate that, or some kind of understanding that is firm, or some kind of mandate in the law on a period of time. Otherwise, we simply will not be able to gather the information on guys that are talking. These guys are as smart as y'all are. A lot smarter than what we are up here. These guys that want to do bad things to us. And they're going to figure out their way around it. It's already happening. We see it. Mr. Woods could tell you some things that would scare folks to death about the way some of the folks in the terrorist world are reacting to revelations by Mr. Snowden. And as we sit here today giving away this kind of information to terrorists, I assure you, there are folks watching this who are making notes, and they're going to use those notes to try to avoid whatever type of system we ultimately come up with. So we've got to be mindful of that as we try to carefully craft this legislation that protects privacy rights. We all agree that that needs to be done, but at the same time protects Americans. Thanks, Madam.